Good evening to the participants of the JCJ Andhra Pradesh as well as the Telangana state. Karibu sana, welcome to my class. And today that I am going to deal the Indian Evidence Act 1872 multiple choice questions. Yes, without wasting the time, let us go to the point of our study.
Sir, questions are not displaying.
No. Just now I displayed. Yes, now the questions are displayed over here. Be ready to shoot. First question. How many sections are in chapter 11 of the Law of Evidence Act? Option A 1, option B 2, option C 3, option D 4.
Option A 1.
Option A is the right answer. There is only one question is there, section is there in the first question. That is chapter 11. Second question. What are the principles of the Indian Evidence Act? Cardinal principles of law of evidence. Number 1, evidence must be confined to the matter in issue. 2, hearsay evidence must not be admitted. 3, best evidence must be given in all cases. 4, in criminal cases, there are 3 types of the witnesses called to testify in a trial. These includes eyewitnesses, expert witnesses, and appeal witnesses. Options goes in this manner. A, 1 plus 2 plus 3. B, 2 plus 3 plus 4. C, 1 plus 3 plus 4. D, 1 plus 2 plus 3 plus 4.
Option A 1 plus 2 plus 3.
Why fourth one is wrong? Statement is wrong.
Appeal witnesses is not there, no, sir.
Appeal witnesses are not there. Character witnesses are there. In the fourth, I wrote, in criminal cases, there are 3 types of the witnesses called to testify in a trial. These includes eyewitnesses, number 1, expert witnesses 2, and character witnesses. I removed the character, I put the appeal witnesses. And hence, fourth one is wrong. The right answer is A, 1 plus 2 plus 3. Now the third question, unmute and read.
Doctrine of Fruits of Poisonous Tree is written by Divya Ashwini and discusses the concept of evidence gathered by option A, unlawful means, option B, prohibited means, option C, illegal resources, option D, illegal means.
Shoot.
Option B, prohibited means.
WRONG.
Option C, illegal resources.
WRONG.
Illegal means, sir?
Illegal means is the right answer. The D is the right answer. Doctrine of Fruits of Poisonous Tree is written by Divya Ashwini and discusses in the concept of the evidence gathered by dash illegal means. Did you hear any time doctrine of fruits of?
Sir, voice em clarity ga vinapadaట్లేదు.
Yeah. Because there is something would be there, but definitely the recorded
Sir,
voice you will hear it.
Clarity ga vinapadaట్లేదు voice.
You will hear it definitely because there is some disturbance would be there. It will be cleared. Now it will be cleared. Yes. So this is the illegal means is the right answer. That is the D is the right answer for the doctrine of fruitful poisonous tree. Now the fourth question. The doctrine of fruits of a poisonous tree is an extension of the exclusionary dash. A, rule of evidence. B, burden of proof. C, relevant fact. D, presumptions.
Option D, presumption.
WRONG. Second option.
Option
Burden
A,
of
rule of
proof.
evidence.
Burden of proof.
If you say burden of proof, WRONG.
Yeah.
Rule of evidence, option A.
Option A is the right answer. The doctrine
Rule
of
of
fruits
evidence.
of poisonous tree is an extension of the exclusionary rule of evidence. Now, fifth question. The phrase fruits of poisonous tree is an dash common law principle. Number A, Anglo-American. Option B, Anglo-Franca. Option C, English. Option D, prudent.
Prudent.
WRONG.
Option C, English.
WRONG.
Anglo-American, option A.
Anglo-American concept, it is common law concept. And it is the American concept, but seldom will you use it in the law of evidence, but it is not actually parallel, but in certain cases it can be considered. Sixth question. The Supreme Court in 1973, in the case of Dash, deliberated on the issue of admissibility of evidence that is illegally obtained. In the present case, it was telephonic conversation that was recorded through a sting operations against the wishes of the party. That is the fruits of the poisonous tree. So that is the case law is A, S. Pratap Singh versus State of Punjab. B, R.M. Malkani versus State of Maharashtra. C, N. Sriram Reddy versus Sri V.V. Giri. D, Yusuf Ali Ismail Nagri versus State of Maharashtra.
Option A, S. Pratap Singh versus State of Punjab.
WRONG.
Option C, sir.
WRONG.
Option D.
WRONG.
Ali.
B is the correct answer.
R.M. Malkani versus State of Maharashtra, and where telephonic conversation are tapped by the sting operations, which is against the fruits of the poisonous tree, but in certain cases it will be allowed. Of course, feedback here I am giving. The reason given by the court in the R.M. Malkani case was that if the evidence was admissible, the manner in which it was obtained is irrelevant. The judges have the discretion to disallow the evidence in a criminal case if the rules of the admissibility of evidence would operate unfairly against the accused. No one can be witness in his own case. There would not be any force against the accused, which article says. I told you already, number one, double jeopardy. Number two, when the offense is committed, that will be counted from that day onwards, the punishment. Number three, there would not be any force against the self-incrimination. What is that article? Here I have mentioned here. Seventh question.
22.
Yeah, now we'll discuss it. Seventh question. In R.M. Malkani versus State of Maharashtra, it was argued that it is not in consonance with the procedure of law and against dash right against the self-incrimination of the Indian Constitution. Article 20, B, Article 21, and C, Article 22, and D, Article 23.
22.
20 subclass 1.
WRONG.
22, sir.
That is a double jeopardy, if I not be mistaken. Self-incrimination, Article 20, Sub-Article 3. Please read the always 20, 20. We don't say article, sub-article, we can say class only. Any Article 20, Class 1, Article 20, Class 2, Article 20, Class 3. See, here the right answer is no one can be forced to do the self-incrimination, that is Article 20, Class 3. Now, eighth question. The court held that it was a piece of evidence that was obtained voluntarily without any force, coercion, and hence the audio recording were admissible as evidence before the court. The court has then on various occasions held that so long as the evidence is not hit by, I repeat, so long as the evidence is not hit by dash of the Indian Evidence Act, it will be admissible even if illegally and improperly obtained. Means doctrine of fruitful, that the poisoned fruit can be used over here. So option A, section 23, 24, 25. Option B, section 24, 25, 26 of the law of evidence. C, section 25, 26 and 27. D, section 27, 28 and 29.
Option C, sir.
Option C, WRONG.
Option B, sir. 24, 25, 26.
Option B is the right answer. 25, 20, 24, 25, 26. If any evidence not hit by 25, 20, 24, 25, 26B of the Indian Evidence Act, then it will be admissible even if illegally and improperly obtained. So this doctrine is the first time I am reading. I did not know this doctrine. Which doctrine? Fruits of poisonous tree. This is the first time I come across this doctrine. In the syllabus also, I think you don't read it. I don't think that the book also it is there. Anyway, let us see that, because when I was referring, I found it. So now let us go to the 9th question. Dash of the Indian Evidence Act defines when the person makes a statement as a cause of his death or as any of the conditions of the transaction that led to his loss of life. That is nothing but a dying declaration. So which section says? Option A, section 32. Option B, section 32, subclass 1. Or option C, 32(2). And D, section 32(3).
Option B, 32, class 1.
Yes, it is option B, section 32, class 1 is the dying declaration. What is the famous case law in the dying declaration? That the Privy Council case law. Not Andhra case law. Andhra case law also there one. And there, jesters also able to dying declaration. That is decided in that case law. Jesters also a dying declaration. Because his throat, larynx was slit and he could not speak. And he made with the signs and gestures. So that is also equivalent to the dying declaration. What is the famous case law, English case law, where the Privy Council decided?
Pakala Narayana Swami.
That is Andhra case law. Pakala Narayana Swami is the Andhra case law. But I am saying English case law. R versus Abdullah. R versus Abdullah is the next. We can say that Pakala. What is repeat? Pakala.
Narayana Swami versus King Emperor.
Yes, that is also a famous case law. That is the Andhra case law. Now, 10th question. The High Court had rejected the carbon copy as evidence. It said a carbon copy of a document which is signed by both the parties cannot be termed as the original document under dash of the Evidence Act. A, section 60, B, section 61, C, section 62, and D, section 64.
D, 64.
WRONG. Option is section 62.
62. C, sir, 62.
C is the right answer. Carbon copy, though it is signed by both the parties, but cannot be deemed as the original document. Which one? Carbon copy. Now, could you see the carbon copies now?
No, sir.
The famous company, can you tell me what is the famous company carbon copies will be manufactured? Corrects. Now let us go to the next question. It is the 11th question. One more I added. 11th question. In dash, the Privy Council said that it is not a sound rule to act on the uncorroborated evidence of a child. This is only a rule of prudence and not law. It is decided A. Bhushan Singh versus Emperor. B. Abbas Ali Shah versus Emperor. C. State versus Shankar Prasad and another. D. Emperor versus Kanhaiya.
Option B, Abbas Ali Shah versus Emperor.
Abbas Ali Shah versus Emperor. The Privy Council said it is not a sound rule to act on the uncorroborated evidence of a child. This is only a rule of prudence and not law. Now the 12th question. In dash, Chief Justice Rankin of Calcutta High Court observed, I quote, there is moreover no rule of law that if a jury thinks that a witness has been discredited on one point, that may not give the credit to him on another, not on other. The rule of law is that it is for the jury to say. There can be no question as a matter of law rejecting the evidence of such a witness, either so far as it is in favor of the party calling the witnesses, or so far it is not, is in favor of the adverse party. That is decided option A, Emperor versus Baburao Tatyarao. Option B, State of Rajasthan versus Salim. C, Prafulla Kumar Sarkar versus Emperor. D, Rima Naik and others versus the state.
Option C, Prafulla Kumar Sarkar versus Emperor.
Prafulla Kumar Sarkar versus Emperor, that was decided. Now 13th question. In dash, it is held that merely because the court gave permission to the public prosecutor to cross-examine his witness, describing as a hostile witness, does not completely efface his evidence. The evidence remains admissible in the trial and there is no legal bar to base conviction upon the testimony of such witness. A. Palvinder Kaur versus State of Punjab. B. Bhagwan Singh versus State of Haryana. C. Harun Haji Andullah versus State of Maharashtra. D. Nishikant Jha versus State of Bihar.
Option D, Nishikant Jha versus State of Bihar.
WRONG.
Option A, sir, Palvendra Kaur versus State of Punjab.
WRONG.
Bhagwan Singh versus State of Haryana.
Bhagwan Singh versus State of Haryana, it is held that merely because the court gave permission to the public prosecutor to cross-examine his own witness, describe him as a hostile witness, does not completely efface his evidence. The evidence remains admissible in the trial. There is no legal bar to base conviction upon the testimony of such witness. Now 14th question. In dash, witness W was examined as an expert in Muslim law. The High Court rejected this and held that evidence was inadmissible. The court must decide the law, not the witness. I repeat, the court must decide the law, not the witness. But experts may be a witness to prove foreign law. A. Aziz Banu versus M. Ibrahim. Option B. Nadir Hussain versus Sadiq Hussain. Option C. Diwan Syed Ali Rasul Ali Khan versus Altaf Hussain and others. D. Abdul Fatah Muhammad Ishaq and other versus Rasamaya Dhur Chowdhury and others.
Option B, Nadir Hussain versus Sadiq Hussain.
WRONG.
D, sir, Abdul Fatah Muhammad.
WRONG.
Aziz Banu versus Ibrahim. Option A.
Option A, Aziz Banu versus Muhammad Ibrahim. It says it is admissible. 15th question. In dash, It has been observed that the section 118 of the Evidence Act envisages that all persons shall be competent to testify unless the court thinks otherwise. In summing up the various judgment on this issue, that is what court had to say. Decided in the case of A. Marbat Non-Sage versus State of Meghalaya, B. Darshan Kumar versus Pushpalata, and C. Lokesh versus State, D. Nivruti Panduranga Kakote and others versus State of Maharashtra.
Option A, sir.
Option A, Marbet Non-Seji versus State of Meghalaya. That is the right answer. 15th question is the right answer. Now 16th question. Dash of the Evidence Act does not preclude a child from being a witness. A. Section 115. B. Section 116. C. Section 117. D. Section 118.
D.
Say full.
Shameful.
Say full.
Section 118.
D. Section 118 is the right answer. Section 118 of the Evidence Act does not preclude a child from being a witness. Of course, there is a old direct test would be there whether the child is having the mental maturity to take his evidence as a conclusive evidence or not. There is a old direct test would be followed over there by the judges to authentify the child witnesses. Okay. 17th question. The apex court in dash, which considering the evidentiary value of the chance witness in a case of murder which had taken place in a street and a passerby had deposed that he had witnessed the incident observed as under. I quote, if the offense is committed in a street, only passerby will be the witness. His evidence cannot be brushed aside, lightly or viewed with the suspicion on the ground that he was a mere chance witness. However, there must be an explanation for his presence there. I unquote. It is observed in the case of A. Sadbir versus State, B. Lunaram versus Bhupat Singh and others, and C. Sachde Lal Tiwari versus State of UP, D. State of Haryana versus Krishan.
Option A, Sadbir versus State.
WRONG.
B, sir. Option B.
Option
Lunari
WRONG
versus
if you say
Bhupat
B.
Singh.
Lunaram versus Bhupat Singh and others.
Option C, sir. Sachache Lal Tiwari versus
Sachache Lal
State of
Tiwari versus State of UP. That is the right answer. Even a passerby, evidence can be taken into consideration and we should not overlook because any murder is happened or occurred in the street. Only passerbys are there. That is, pedestrians are there. So that is observed in the Sache Lal Tiwari versus State of UP. Now 18th question. Dayal Singh case. It is a famous case. Dayal Singh case deals with dash. An eyewitness version cannot be discarded by the court. B. Dying declaration not kept aside. C. Guiding principle of dealing with an expert opinion. D. The doctrine of estoppel can be applied.
Option C, sir. Guiding principle for dealing with an expert opinion.
Yes. See, guiding principle for dealing with an expert opinion is observed in the Dayal Singh case law. And in the case of Dash, the Supreme Court cautioned that though this doctrine is very much useful, this golden rule has to be used with caution and cannot be used in any type of doubt. Accused is to be given only a reasonable benefit of doubt. As such, if the principle of Even if 1,000 people may get acquitted, one innocent person should not be punished. That is the based on the criminal principle beyond the reasonable doubt. Is applied in all the cases and is relied upon the indiscriminately. It may cause an adverse effect on the administration of justice and the society may lose faith in it. Besides, it is not desirable to acquit or convict accused wrongfully. So that was the case law and that was the thing observed in the A. State of Rajasthan versus Ganesh Dash and others. B. State of Nagaland versus Lipak Ovo and others. And C. Shivaji Saheb Rao Bobde and others versus State of Maharashtra. And D. Tuesday versus Unknown.
Option C, sir. Shivaji Sohabra Babu and another versus state.
Yes, it is a Shivaji Saheb Rao Bobade and other versus state of Maharashtra. This decision is given. That is beyond the reasonable doubt. So these are the things today I prepared, but it took a lot of time and my time factor also not there. But I told you now, I dealt so many supplementary questions I can ask you now. I don't know whether you could be able to make it out or not. What is the act number of the Law of Evidence Act?
Act 1.
I
Act
appreciate-
1.
I appreciate. How many times the law of evidence is amended? Yes, I'm checking whether.
3, sir.
How many times?
3, if I'm not wrong.
I say how many times the law of evidence is amended? Did you hear my question first?
3 times, sir.
Only 3 times. Only 3 times the law of evidence is amended. I'm thinking where this disappeared. I kept it open. Google. How many times law of evidence amended? Or what is the last amendment also? How many? Oh, it is giving some other. Indian September Google website promotions. No, not this one. Hide window cancel. Maybe choice. No. I don't know if I make something, then a problem would be there later on for me. Better I can open the other one. How many times law of evidence is amended? Means Indian law of evidence. See, this is the supplementary questions. Amendment to the Indian Evidence Act. Exhaustive oral and repeal hearsay, but how many times? That's more important. No, this is not shown over there. They say merely the Information Technology Act. They made it out. So supplementary question, please note the point. And which is the last amendment? Which is the, 2019.
2019.
Yeah. Here it is given, last amendment 2019. Let us see that what it is exactly says. And what is the act number of the last amendment 2019? Even that also.
Act
Act 34 of
2019.
2019.
No, let us see that because it is still opening 2019 act. Because it is a PDF file, it takes time. It depends upon the, because I am using recording, I am using sharing, I am using this thing. So load is more. And that to be I am using the Vodacom. Here Voda is very much fast. A broadband. From my home, I am dealing this class. Now the time here is, 7:16 and the India time is 9:46. Yeah, it is open. The Evidence Act 1872 was as it amended up to the 34 of 2019. Act number 34 of the 2019 and as of 17/9 2019. So this is the latest amendment and the relevancy of the fact preliminary. Of course, we need not make it out because there are many things are made. But what we interested is only when it is amended. That's and how many times is amended? Again, another question. How many times it is amended? And estoppel comes under which section of the law of evidence?
115. 115.
I appreciate.
115.
What about res judicata?
11 of
Section six.
CPC.
Yes.
Regesta 6.
Regista also
Okay,
there.
there's some sections.
What is the presumption of death?
Section 4, presumption.
Of death. If a person could not be here more than 7 years,
More than
consecutive,
7 years.
presumption is
Okay,
that
7
he
years.
is dead. Presumption of death under the law of evidence. If 7
not
years,
7 years.
consecutive, that is the more important, consecutive. So that is the another factor. These laws only govern the circumstances where a person is proved dead. It is for the
7 years.
particular reason that the court was forced to borrow the provision of the Presumption of the Death Act 2013. Under this, a person presumed to dead if has not been known to be alive for the period of at least 7 years. Presumption of death would be there. And what is the section which deals with? I think it is a 107 and
107.
108 of the Evidence Act, which allows the presumption of death of a person for 7 years. So that is the
Yes,
other
sir.
point, supplementary question. And what is the presumption as to who dies first? Who dies first?
Younger survived the elder.
Yes, I appreciate. Why? Why? Logic.
Because the elder will die first. And then the younger
Logic.
will-
The elder is having the less resistance power. The younger is having the more resistance power. Hence, elder die first and younger die later. Is it clear?
Yes.
Suppose both are having the same age. Both are the twins. Then, who born first, elder, who born later is younger. Am I right?
Yes, sir.
So that is the another presumption we can make it out. What is the presumption of death in the law of marriage?
7 years.
Dowry. 7 years.
Check it here, what is written. A party to a marriage can contract another marriage on the basis
In
of the
5
absence
years of marriage.
of his spouse if the spouse alleged to be absent has not been heard for the 5 years by those. Is it Indian law? Let us check it whether it is Indian law. Have it where this presumption is spouse dead. First we also check whether it is Indian law. FB attorney. How long the presumption of death is there? No, I think it is not the FB attorney. It's another country law. Let us check it whether it is a FB attorney. Presumption of death. Because almost all the evidence is everywhere the same. Yeah, FB attorney, the Tanzanian law. Is a Tanzania.
7 years of marriage.
But generally, we say 7 years is the presumption. Even the Law of Marriage Act also says, not the Hindu Marriage Act. The Hindu Marriage Act also will say in that matter the 7 years absence. The Civil Practice Medics Court, the chapter 133. No, this is another act. Here 118A. This is this is another act. So supplementary questions are there are many. I downloaded the law of evidence here so that I could deal. I don't know where I could. Kuti, Indian law of evidence? Indian law of evidence or law of evidence? Evidence Act, Bare Act. See, I wrote. I know that I downloaded it because to ask such a questions to you. Because the first question which I framed is from this only. The first question which I framed, that is chapter 11. See, this is the chapter 11. Only one section is there. Another schedules. This is repealed Act 1938. So there is no schedule. Is it clear?
Yes, sir.
And in my earlier video, if you happen to see, how many sections are repealed in the law of evidence? I asked such a question. See, second is repealed and schedule is repealed. The other sections are not repealed. Check it. And I think 44 or 45, another is repealed. Or the last one is repealed.
45 is there, sir. Opinion of expert.
Yeah. See, in the last class, because I remember very well, only two sections are, one is a repeal section, REPAL, repeal, only two, yes, only two. One is schedule I repealed, and another is section 2 is repealed.
Section 2.
Only two sections are repealed in the law of evidence, the Indian Evidence Act, 1872. In my last video, I remember it because I framed this question by looking on it. And I framed also the so many questions in my earlier video. If you happen to hear, I made the chapters and its explanations. For instance, you take part 2 deals about the unproof. Part 3 deals about what? I made the match the following.
Production.
Even I made chapters also. Match the following and the mismatch in my last video. And just to type it, law of evidence MCQ, it's enough. You will find many videos are there because the same type of the questions I prepared for the LLM, the same type of the questions, the multiple choice questions prepared for the 3, 4, 5 times I prepared it. So if you happen to read my 5 times, and each time is, I try to make a different angle of asking the question. And I told you already, this time I made that R.M. Balkani's case law, state of Maharashtra, the fruits of poisonous tree. Whether we can forcefully tap the phone by using the string methods and use against the person. So they say, unless it will hit by what are the sections? 124? 125?
24, no, 24, 25, 26.
So 24, yeah, not 124. 24, 25, 26. Unless it will not hit the law of evidence, these sections, yes, it can be used against him. So in that way that I made several questions. Of course, here I did not make because what the 77 says, what the 75 private document, what is the 74 public document, because there is a probability also they will ask you. 74, match the following. 75, match the following. 76 or 77 are presumptions. They may ask. And how many types of the witnesses are there? Can you tell me? Type of the
3
witnesses.
types.
Yes, anyone?
3 types of witness.
How many types of witnesses in the law of evidence, Indian law of evidence?
3, sir.
Character witness also we discussed. Yeah, in the criminal cases, there are 3 types of the witnesses called to testify in the trial. This includes eyewitnesses, expert witnesses, and character witnesses. I framed the question this one. Instead of I removed the character, I made appeal witnesses. So 3 types of the witnesses, we can make it out. And if I ask the sequence, eyewitness come first, expert witness comes next, and the character witness comes third. That is the sequence. And the witness and types of the witnesses under the Indian Evidence Act. And what are the sections deals about this? Is there any sections are given? Because I'm checking now. Witnesses and
Yes,
type
sir.
of witnesses, Indian Evidence Act. And who is a witness? Section 118 of the Indian Evidence Act. Competent witness is one who has the capacity and ability to understand the question put to him by the court.
Put to him.
If he has understanding of the question and the ability to give the rational answer, then he is a competent witness. Can a child will be the witness? Yes.
No.
A child can be also a witness, provided there is a test I told you. What is the test made by the judges to know the maturity of a child? World test. I will check whether it is given here. Interested witnesses, chance witnesses, stock witnesses, eyewitnesses, official witness, related witness. So these are the types of the witnesses. So there is a possibility that they may ask it, which one is odd man out. So they will give the witnesses here, interested witnesses, chance witnesses, stock witnesses, eyewitnesses, official witnesses, related witnesses, and I write it passerby witness. I write the passerby witness, whether it is a witnesses will be taken into consideration. The law will take into consideration passerby witness if the murder is taken place in the street. But it is not a type of witness. Is it clear?
Yes, sir.
And stock witness. The word stock means something which stored or kept in a future use as per the availability. The stock witness is a person who remains at the back foot of police and comes in front of as per direction of the police. The testimony is not very reliable, and the court always opts not to stand on its testimony. Such witnesses are highly disfavored by the judges. So stock witnesses will be disfavored by the judges because they act on the direction of the police. Is it clear? Can the eyewitnesses are reliable? A person
Yes, sir.
who from his
Yes,
eyes
sir.
witnesses any act or scene of the crime is an eyewitness to the offense. An eyewitness may be any person like a stranger or relative or any other person, even a passerby. From the perspective of the witness, an eyewitness is an important evidence in solving a case. It is generally said that anything can betray but not the eyes. So, eyewitness having more priority. For example, A is a shopkeeper and sits in his shop till midnight, 12 midnight. One day, B and his brothers, in a feeling of revenge, reach C's place, and B and his brothers push C out of his house and beat him very badly. In some time, C's head starts bleeding. Looking at B and his brothers ran away from the place, leaving C on the floor. Here, a shopkeeper, is an eyewitness and who saw the crime taking place can give testimony against the B in the court because he was the present at the time in the shop. Then you can ask it, according to the Shops and Merchants Act, can the shop will be opened up to 12 o'clock midnight? Yes?
No, sir.
Answer is no. But he can give the reason. Sir, I am repairing the door, or he can repairing the lock, and hence I could not lock it in properly. Then I called the lock maker and repair it. Then I locked it by the time it is 12 o'clock. But I am not transacting any business. I am trying to close my shop. That's why it took so much time. Can the judge will accept such a statement unless it is corroborated with the A lockmaker came over there and he certified that yes, I was present. I made it, and he went away immediately. So official witness, medical witness, expert opinion, medical witness, forensic witnesses, forensic report. Even the person who gave the report has to be present in the bone to give orally also. Am I right?
Yes,
Answer
sir.
is yes. What about the drunken man? Can a drunken man would be a witness? Because at the time he was drunken. Anyway, these are the certain things which I would like to share with you. And you have to go through, because they can ask you from any angle, not necessarily from only one angle. Are you following me?
Yes, sir.
Yes, now the time is 7:32 here, local, and there 10:02. By this time it should be closed, Cisco WebEx. I don't know what was the reason it is not closed today. So I am showing you the different ways where the questions will be framed. And for instance, what is the primary evidence? What is the secondary evidence?
Primary evidence is the document itself produced. Secondary evidence is the certified copies, contents of original document. All these are secondary evidence.
If a witness comes himself and give the statement in the
Primary
presence
evidence.
of the court, does it amount to the primary evidence?
Yes, sir.
So section 62 deals with the primary evidence and section 63 deals with the secondary evidence.
Secondary evidence.
So sometimes they can ask you such a question also. As the following. And what is public document and private document? Rokia, still you are waiting. How many times you joined? Public document 74 and 75 is the private document. Can the public document would be produced in the court? Such a bulky man?
No, sir.
Or it's only
No, sir.
attested copy?
Attested copies.
A competent authority should have to sign over it. Then it can be
Yes, sir.
used as a, then it will be marked as an exhibit. Am I right?
Yes, sir.
So private document and public documents, these are also presumptions. And presumptions as a genuine of the certified copies, section 79, it will deal it to section 90 capital A. These are all the presumptions. So supplementary question, presumptions deal on the inner law of evidence from the section dash to section. Then the answer is section 79
79
to
to 90A.
90 capital A.
90A.
Capital A. That is a presumption as to electronic record 5 years old. Presumption as to document 30 years old. Presumption the due execution documents not produced. And what about the electronic messages? A. And the presumption
Electronic
of the
agreement.
yes, telegraphy. Of course, now the telegraphy messages are not there. Telegraph is no more now used. Am I right?
Yes, sir.
Did you see the telegraph?
No, sir.
Yeah, by the time you were not born. There was a telegrams are there, tuk 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 tuk, and they will make the sounds, and these sounds will be transmitted over there, and they deciphered. Then the printed will come out there. Generally, when you receive a telegram, means somebody is kicked the bucket. Am I right? Did you know what is meant by kicked the bucket?
Yes, sir.
What is means?
Dead.
Dead. So generally telegram used come only for that reasons, earlier times. Of course, because of the IT technology, now we can make it out, many other things. So evidence has to document, even a digital signature is a valid or not?
Valid.
Electronic signature.
Valid, sir.
It's a valid.
67A.
Of course, now recently the judgment is given. Can you send the summons through the WhatsApp?
Yes, sir.
But Supreme Court say at
No,
the time
no.
of the pandemic it will be allowed. But now why you are
But
sending
is
the
not
summons through
allowed.
the WhatsApp? Yes? The
Sir,
Supreme
yes.
Court made a such a judgment. Did you see it?
See, sir.
In the pandemic it was allowed, but not now. A notice should be given as usual manner in a documentary form in the hard copy. Because of the pandemic, it can be allowed over there, but now it cannot be. Of course, if the situation is there in the particular area, it can be allowed. If not, it should be handed over to the party. Even the party refused it, our door is closed.
Based in some
Yet,
conspicuous
the presumption is
delivered.
delivered.
Served.
How many days?
30 days.
Is it 30 or 15?
30 days. Summons. 30 days.
What about the notices?
15 days.
Anyway, sometimes they will ask the practical questions also. And that also one should have to keep in mind how we can make it out. How many parts are there in the law of evidence?
3 parts.
How many
Relevancy
chapters
of
are
fact.
there?
167 sections. 11 chapters.
And how many sections are there?
167 sections.
Yes, now you totally know. How many are repealed? 2. What are they?
2.
Section 2 and schedule.
Schedule and section 2.
Now you can become an expert in the feature, the law of evidence. Before the law of evidence 1982, what is the earlier act? Okay, father of the law of evidence?
Sir James Stephen, sir.
Yeah. But I forgot in the first name, Jeffrey Stephen something. No, let us make it. Because these are generally the questions supposed to be asked. Of course, these are all we asked. Several times I asked. I asked in a different style also. Not one style. Father of the law of evidence. 1872. Indian Evidence Act introduced a standard set of law applicable to all Indians. The law is mainly based upon the firm work of the Sir James Stephen. Sir James Stephen. So generally they wrote Sir Stephen, or sometimes James Stephen. They don't write the James again. And who could be called the founding father of his comprehensive piece of legislation. And that is the one we should have to remember it. And the historical background was there. Introduction to Indian Evidence Act, Legal Service Authority. Then you can find it, many of the questions. The interesting section. What is the section 10?
Conspirators. Things said are done by conspirators.
Okay. I think this I discussed somewhere last time. The Evidence Act 1872 provides all the necessary information regarding the admissibility of the evidence in the court. The draft of the Evidence Act was created in the 1850s by Henry Sumner, Maine, but it was unworkable. Then British Raj, of course. Irrelevant facts are relevant, section 11. And 10th, which you can find interesting if you are not the law student. Of course, he has given the police officer can prove it against if you confess in front of him, but you also cannot confess in front of the public police officer while in the custody. That is the section 25 and 26. Confession before the police officer is not admissible. Is it right?
Yes, sir.
What is the truth sits upon the lips of a dying man? Section 32. Because
The
dying man
person
never
who is
tell
about
the
to
wrong.
die would not lie.
A dying man would not lie. That is the concept.
Yes, sir.
So that's why I say truth sits upon the lips of a dying man. And this is section 40. Dijavo. I don't know, we are all heard about the res judicata. And section 11 of the Code of Civil
11.
Procedure, 1998. Double jeopardy. Section 403 of the Code of Criminal Procedure. Again, section 20 and class 2, double jeopardy. And 1898 CRPC also there. And they compared it here. And a person once convicted and acquitted not to be tried by the same offense, section 40 of the Evidence Act, double jeopardy. I already told in my earlier class, I think last class I told you, what is a famous case law in the double jeopardy. For the same cause of action, a person cannot be convicted twice. In my last class, I referred that case law. And it's a Maharashtra case law, not Maharashtra, state of Bombay. Can anyone? Maqbul Hussain versus
State of Bombay.
state of Bombay, I referred it. And the last jury trials under the Indian Penal Code, which is the last case law. From that onwards, there is no jury trials. Otherwise, there is a jury trials also there before. And on that case law, a English movie was, sorry, a Hindi movie was made where Akshay Kumar is the hero.
Nanavati, sir.
K.M. Nanavati versus State of Bombay. It's the last jury case law. And the case law deals about what? Provocation. And which section say about the provocation in the IPC? Relevance is there. So the case law, they say it is not amount to provocation because he shot the paramour next day, not on the spot. What is paramour? Paramour.
Awesome.
A married woman keeping another person for the sex is called the paramour. Like we can say for the woman, we can say concubine. Of course, in some places, concubine is allowed. But in Hindu law or the Muslim law, it will not be allowed unless you want to marry, you can marry the four, up to the four in the Muslim law. But the Hindu law will not allow more than two wives. If it is so, what type of the offense is committed?
Bigamy.
What is the section?
494.
494 or
IPC.
498?
IPC 494.
Okay. So these are the things which I want to make it out today. But today's Cisco WebEx is very much kind enough because now time is 10:15 and local time is 7:45. And tomorrow I will come with some more questions in the law of evidence. But meanwhile, may you watch my earlier videos also. With this, I would like to wind up today's class. And goodbye. Jai Hind.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभाशिष मागे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे।
सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।